Hello friends, very warm welcome to my business laws channel. Friends, I hope that all the teachers in your classes, must have finished the syllabus for your business laws paper. So this is the revision time now. And now friends, I'll take up the question papers which have been asked in the DU examination in the previous years. So the question paper is before you, which was asked in May, June 2018. And this question paper I'm going to discuss now. So let us start now. The very first question is, friends, explain the meaning of a contingent contract. What are the provisions relating to contingent contracts? Friends, as far as BCom syllabus is concerned, DU BCom syllabus, this particular topic, contingent contract, is not a part of syllabus. But if you are doing BCom from any other university, okay, then I would like to explain. What is contingent contract? Contingent contract has been defined under section 31 of the ICA 1872. It is a contract to do or not to do something. If some event which is collateral to such contract does or does not happen. So friends, it is conditional contract, where the event is dependent upon the happening or non-happening of the event. The contract is dependent upon the happening or non-happening of the event. If an event happens, then the contract is valid. If the event doesn't happen, then the agreement will be void. Friends, insurance contract is a very good example of contingent contract. Insured person will get the compensation from the insurance company if his vehicle gets damaged, is destroyed, he meets with an accident. Then only. If everything goes well, then he's not going to get any compensation from the insurance company. What are the provisions relating to contingent contracts? The provisions have been provided under sections 32 to 36 of ICA 1872. So 5 to 6 points are there. So those points we will have to write along with the examples. Moving ahead, friends, coming to the B part. A husband executed a registered document in favor of his wife. After referring to clause and agreement between them, he promised to pay for her separate maintenance and residence. On his failure to pay, the wife sued him in the court of law. Will she succeed? And now, friends, I would like to answer this question. This is a case study based question or application based question, application of law. This is from the chapter consideration. Exceptions to the rule, no consideration, no contract. If any agreement is made on account of natural love and affection, though there is no consideration, but still that agreement is valid in the absence of consideration, provided 4 conditions are satisfied. Agreement must be made in writing, it should be registered, it should be made on account of natural love and affection, and the parties must stand in near relation to each other. So friends, in this given case, that out of 4 conditions, 1 condition is not going to be satisfied. So this agreement was not made on account of natural love and affection. The second line of the problem case study specifies after referring to quarrels and dissent. He promised to pay for her separate maintenance and residence. But later on, he did not pay. Wife sues him in the court of law. Will she succeed? She will not succeed. Because this agreement was not made on account of natural love and affection. And Rajlakhi Dabi versus Bhutnath Mukherjee is a landmark case regarding this given problem. Now you can make a mention of this. This will create a very good impression about you on the evaluator. Moving ahead, friends, now I'll take up choice question. Define undue influence. How does it differ from coercion? undue influence has been defined under Section 16 of ICA 1870. Conduct is said to be induced by undue influence if relationship between the parties is such that one of the parties can dominate the will of another, and he obtains an unfair advantage over the other. Dominance. There is relationship of two parties, weaker party and stronger party. And stronger party may dominate weaker party. And that party dominates weaker party and obtains an unfair advantage over the weaker party. Number of examples are there. Relationship of debtor and creditor, landlord and tenant, advocate and client, police officer and accused person. So in all these cases, we may find that, one person may dominate the will of another. And now the second part of the question is, how does it differ from coercion? There is difference between coercion and undue influence. Friends, I have always suggested you that always write the distinction in the tabular form. So first will be the meaning. Okay, coercion has been defined under Section 15 and undue influence has been defined under Section 16. Coercion is committing of the act which is prohibited under IPC. Or, property belonging to the other person may be detained unlawfully. You can put it in your own words, the way I have put it in my own words. Then relationship. Relationship is there in case of undue influence. There is no relationship in case of coercion. And then, friends, many more points are there. Coercion may be exercised by a person who may be a party or may be a stranger. Coercion may be exercised against a person who may be a party or stranger. But undue influence is exercised by a person and against the person, both must be parties to the contract. And then, friends, even the type of force is different. In case of coercion, it is the physical or violent force which is exercised. But in case of undue influence, it is the mental pressure which is exercised. And rights are different. The conduct becomes voidable in both the cases. The right of rescission is applicable in case of coercion. But in case of undue influence, directions of the court are to be followed. So 5 points of distinction you can write in this under this heading. B part is explain the nature and extent of surety's liability in case of guarantee. There are 5 to 6 points which you have to write in the answer for this question. Surety's liability is secondary. It is not primary. Primary liability is that of debtor. Surety's liability is always secondary. It is dependent upon the debtor's liability. If he commits default, then only the liability of surety will arise. Liability of surety is immediate. The moment he commits default, the liability of the surety will arise. Then surety may always limit his liability in case he may always limit his liability. There is no compulsion on his part that he must give the guarantee for 100% debt. He may give the guarantee for 100% debt, or he may say, I will guarantee only 80% or 70% of the debt. Then his liability is always coextensive with that of principal debtor. It is always equal to the liability of principal debtor, provided surety has given the guarantee for 100% debt. And then what is the liability of the surety? When the agreement or contract between the creditor and the debtor becomes void or voidable. So friends, all these points you will have to write, and you can also give examples. So coming to C part, A supplied rice and wheat to the wife and children of B who is lunatic. B has assessed worth 1 lakh of rupees. On non-payment, can A proceed against the assess of B? Friends, this particular given problem is from the chapter quasi-contract. The very first point under the quasi-contract under section 68 is necessities or necessaries supplied to the person who is incompetent to contract or to the person who is dependent upon such incompetent person. And then you know that lunatic is one of the incompetent persons. And wife and children of lunatic person. Okay. And then you know B has assets worth rupees 1 lakh. Okay. So on non-payment, A can always proceed against the assets of. There's a provision which has been provided. Because rice and sugar, they fall under the category of necessities. So when we talk about incompetent person's liability, no personal action can be taken against them, but property of that person is always held liable. Coming to the second part, would your answer be the same if B, instead of being a lunatic, were a minor? Yes, friends, our answer is going to be the same. Because like lunatic person, minor person is also incompetent to contract. Then you know whatever property minor has from his estate, amount can be recovered. So our answer is going to be the same. Now moving ahead, friends, question number second is define the term goods. Define the term goods in the context of sale of goods. Distinguish between ascertained and ascertained goods. Unascertained and ascertained goods. Goods term has been defined under section 2, subsection 7 of the Sale of Goods Act 1930. It includes all movable goods, but it excludes, money and actionable claims. Money which is in circulation, actionable claims are the debts which can be, enforced through legal action. Movable goods, tangible goods, all are included in the term goods. And on the basis of case laws, in the courts, number of items are being included under the term subject matter of contract of sale. And then there is distinction between ascertained and unascertained goods. Ascertained goods are those goods which are identified and agreed upon, at the time of formation of contract or subsequent to the time of formation of contract. But as against this, unascertained goods are those goods which have not been ascertained yet. Say buyer wants to buy WagonR car, model, color, everything has been specified by the buyer. This will fall under the category of ascertained goods. And if buyer has the intention of buying car, but he is not clear about which model, which color he should buy, then it will fall under the category of unascertained goods. Coming to B part, discuss two situations when non-owner can pass on a clear title of the goods to the buyer. Friends, this question is from Sale of Goods Act. Nemo that quod non habet. Non-owner is not allowed to make a valid sale. But there are some exceptional cases where non-owner can also make a valid sale, and these exceptional cases have been provided under section 27 of the 27 of the Sale of Goods Act. So friends, here two situations where non-owner can also pass a valid title. These are, friends, this you will find under the chapter number 16 in my book, Business Law book. Okay, now with the title, Transfer of Title is the chapter. The mercantile agent is not the owner, but he can always pass valid title. Title by estoppel, or person who is having the goods, possession of goods under wardable contract. He is not the owner. He can always pass a valid title to the buyer. Sorry, friends. So friends, apart from this, there are a number of cases. 8 points are there. But since 2 points have been asked, you should write 2 points along with the examples. What are the remedies available to the seller for breach of contract by the buyer? So there is a breach of contract on the part of buyer. So buyer is the guilty party and seller is the innocent party. Say buyer has not, paid the price. Then seller has the right of lien. He has a right of stoppage of goods in transit, or he has a right of resale, or he can file a suit against the buyer for recovery of price. So whether he can exercise right of lien or right of stoppage of goods in transit, it depends if the goods are in the possession of seller or they are in the possession of intermediaries. If they are in the possession of seller and he comes to know that the buyer has become insolvent, then he has a right to exercise lien. But if he has given the possession of goods to the intermediaries, like railway authorities, shipping authorities, or air authorities, and then he comes to know that the buyer has become insolvent, then in that case he cannot exercise right of lien, but he can always exercise the second right, which is known as right of stoppage of goods in transit. And he can also sell the goods. Buyer has not paid the price, goods are of perishable nature. How long he'll keep on waiting for the buyer to pay the price? Or he has reserved his right of resale. Then without serving the notice, he can sell the goods if the buyer has not paid the price. Or he can always file a suit against the buyer for the recovery of price. See, he has sent the goods to the buyer for as per order, but still buyer has not accepted the goods. He can file a suit against the buyer for non-acceptance of goods. These are the various remedies available to the seller against the buyer. So moving ahead, friends, now the 12th question is where comment on the following statements. Right of stoppage of goods in transit is an extension of an unpaid seller's right of lien. This is right. References and all which are given, they are from my book. If you're not following my book, then in that case, whichever book you are following, you can open the sale of goods chapter and then you can find the answer there. The right of stoppage of goods in transit is of course extension of unpaid seller's right of lien. Right of lien is possessory in nature. So far as the goods are in the possession of unpaid seller, he can exercise this lien. But once he has lost the possession, he has also lost the right of lien. Here, the right of lien ends, then the second right commences, which is known as the right of stoppage of goods in transit. It's very right that it is the extension of the unpaid seller's right of lien. The fact that the buyer of the goods has received the goods does not mean he has accepted the goods. Yes, friends, this is very right. Buyer has a right to examine the goods. Acceptance doesn't mean the goods have been, the delivery does not mean the goods have been accepted by the buyer. Buyer has a right to examine the goods. If he finds the goods correspond with the order, he will accept. And if he finds the goods do not correspond with the order, he has a right to reject the goods. So delivery of goods does not mean acceptance of goods by the buyer. And now coming to C part, which is seller is not bound to reveal the defects in the goods sold to the buyer. So it is not the duty of the seller to reveal the defects to the buyer. It is the duty of the buyer. Caveat emptor. Let the buyer beware. Buyer must be very careful while buying the items, and if he is not, then he has to bear the loss. He cannot hold seller responsible for the loss. But friends, in case of latent defects, seller will be responsible towards the buyer. What are latent defects? The defects which are not visible on ordinary examination. That will be taken as a case of fraud, and the seller will be held liable for that. Coming to question number 3, define the term designated partner. Explain the various provisions in respect of designated partners. DPs. In case of LLP, there are two types of partners, normal and designated partners. Designated partners, regarding this, there are 8 to 9 points. Who is eligible to be designated partner? Who is not eligible to become designated partner? Designated partner has to give in writing that he wants to be the designated partner. He has to give his consent on the prescribed form. He has to obtain digital signature certificate. He has to obtain DPIN, designated partner identification number. He is always liable. For all legal compliances, he is liable. If there is any violation, then there is separate liability for the LLP as well as designated partner. The responsibility is both. Income tax return has to be filed, or accounts are to be maintained. So designated partner is always liable for all legal compliances. Or there are other acts also, which are if any provision of that act is violated, then there is a separate penal provision for the DPs. So friends, all these points, because question is of 10 marks, so all 9 to 10 points you should write. Then B part is define the term LLP agreement. Is it mandatory for all LLPs? LLP agreement, friends, LLP is the agreement where the partners, when they decide to form the LLP, then they enter into the LLP agreement. In the LLP agreement, all contents are there. Who are the partners, who are the normal partners, designated partners, and then capital contributed by them, what will be their rights and liabilities in case of admission, retirement, dissolution of the LLP. So all these points, what will be the profit sharing ratio, interest on capital, okay, and in which form they will bring the capital. So all these points are there. It is not mandatory for all LLPs to prepare LLP agreement. In case partners decide to draft LLP agreement, well, and in case they do not decide to draft LLP agreement, then in that case they will be bound by the provisions of Schedule 1. Schedule 1 contains the mutual rights and obligations of the partners of LLP. Now moving ahead, friends, answer any three of the following. Auditing of accounts of LLP. Again, this is not in the syllabi of BCom course of Delhi University. But this you will find in chapter 22 in my book with the heading Auditing of Accounts of LLP. Auditing of LLP is not compulsory, but there is certain time limit. There is certain limit of the turnover for the contribution. Beyond that, it is obligatory for the LLP that LLP must get its accounts audited. Then restrictions relating to name for proposed LLP. LLP is not free to have any name of the proposed LLP. There are some restrictions which have been imposed by the government. So LLP has to take care of those restrictions. And in case of any violation, there is a penal provision for that. Then declaration of insolvency of an LLP. Again, this heading is from chapter number 24, declaration of insolvency. Whether the LLP can pay its debts within a period of 1 year or not. That is, partners have to declare that LLP is not insolvent. LLP is solvent enough. LLP is able to pay its debts within a period of 1 year. This you will find under the chapter Binding Up and Dissolution of LLP, the last chapter under the LLP Act, and which is the chapter number 24 in my book. Then procedure for change of registered office of an LLP. Registered office is must for LLP. So registered office is a place where all correspondence will be addressed. Letters, documents will be addressed to the LLP. Then change of registered office from one place to another within the same state and one state to another state, the procedure is different. So friends, depending upon that, you will have to write the various provisions. For this, you will find chapter number 20, which is with the title Incorporation or Registration of LLP. Then coming to question number 4, how is CCA appointed? What are his functions under the IT Act 2000? CCA, friends, is the apex body. CCA is always appointed by the central government. Central government has authority to appoint deputy controllers and assistant controllers through the same notification or through subsequent notification. 4 functions of CCA, they have been provided under sections 18 to 25 of the IT Act 2000. So you will have to write all the points. CAs are responsible to the CCA, and CCAs are responsible towards the central government. Regulation of certifying authorities. So what will be the format of certificate, or who will issue the license to the CCA? All these functions are to be performed by the controller of certifying authority. If license has to be obtained by the CA, then CA are not following their duties. They're violating the provisions. Then CCA has the right to suspend their license. So friends, all these are the functions which have to be exercised by the CCA. Then write a short note on electronic signature. Electronic signature was introduced under ITAA. Friends, you will have to write authentication of electronic record by electronic technique which have been specified under Schedule 2 to the ITAA. So friends, you can write uses of electronic signature, or issue of electronic signature, and then revocation, suspension of electronic signature. Then differentiate between cyber contravention and cyber offenses. 5 points of differences are there. You should write all the 5 points of differences, and then 2 cyber offenses. You will have to explain any 2 cyber offenses, because 9 offenses are there under the heading offenses. Any 2 points you can write. The violation of privacy, and then tampering with the computer source document, or cyber trafficking, or you can write cyber terrorism. Okay, and punishment and all, everything you have to cover in the answer. Differentiate between private key and public key. Mainly 3 points of distinction. Both are the keys of key pair. Okay, so friends, 3 points of distinction. Nature of each key is different. Function of each key is different. And private key is private. Public is public key. It is widely known to the public. Private key is kept by the subscriber only. Private key and public key perform different functions. Private key is used to create signature. Public key is used to verify signature. And then private key is not listed in the digital signature certificate. Public key is listed in the digital signature certificate. Explain all these points you should write in the tabular form. Explain the various duties of an agent towards the principal. What are his rights against the principal? The duties of the agent are the rights of principal. Rights of the agent are the duties of principal. So since the question is of 10 marks, 5 points you write for duties, and 5 points you may write for rights against the principal. Like duties, he must follow the instructions given by the principal. He should render proper accounts to his principal. Okay, etc., etc. And then rights, he has the right to take remuneration from the principal. He has the right that if he has incurred any expenditure, he must be reimbursed by the principal. So friends, like this, 5 points you should write in the answer for this question. What is the protection available to the whistleblower under LLP Act 2008? Protection has been provided. 2 points are there, friends, under the heading under section 31 of the LLP Act 2008. So whistleblower, who is whistleblower? Who blows the whistle? Who brings to the notice of the internal management or external people like media or law enforcement agencies about the reporting of the illegal activity. So 2 points which have been given under regarding the protection under section 31 of the LLP Act 2008. Those 2 points you have to cover. Now coming to the choice question, differentiate between bailment and pledge, indemnity and guarantee. So these are the two distinctions, friends. Bailment and pledge. Bailment is broader term as compared to pledge. Pledge is a part of bailment. Both are having different purposes. Pledge has got single purpose only. Bailment has got multiple purposes. Right to sell the goods is available in case of pledge, but right of lien is available in case of bailment. Even rights are different in both the cases. Indemnity and guarantee question is of 5 marks. 5 points of distinction you can write. Number of parties, number of contracts, liability of indemnifier or surety. Okay, and then apart from this, meaning of indemnity and guarantee, you should write, and then rights of indemnifier or rights of surety. Any 5 points, 8 to 9 points of distinction are there. Any 5 points you should write in the tabular form. Write the contents of LLP agreement. About LLP agreement, already I have talked, friends. LLP agreement is not mandatory, you all know. I have told you earlier in the beginning of this question paper what is the LLP agreement, and also I have discussed the content. So friends, I have discussed all the questions in this question paper. And if you still have any doubt, you can always write in the comment section. It is all about the discussion about this question paper. Friends, I hope you are enjoying your studies. Keep smiling and stay healthy always. And do subscribe to my channel and do, press button, to get notifications of my subsequent videos. Okay, friends, goodbye. Meet you very soon.